Am I claiming too much authority for our intelligence scouts or investigators for our grassroots level communities here? Anybody think? I don't hear anybody full of smoke.
Well, my problem is I do not know the contractual requirements of each of the other states. So it's almost impossible for me to make a comment about that without having some knowledge, some pertinent knowledge about the requirements of other states' constitutions.
If I might, Paul, thank you for engaging with me here. Every state except Louisiana has embraced common law?
Yes, that is correct.
Okay. And common law is based on principles. You follow me there?
Common law is based upon custom and usages that have been addressed in common law courts. So in that regard, yes, that would be, principles would be a viable substitute.
If I might, thank you, Matt. Statutes frequently embody common law principles. They frequently clearly state common law principles. But the pre-existing is the common law principles. Statutes merely codify and articulate those common law principles.
Whoa. Charles.
Yeah.
If I may.
Yeah.
Now, this is something I do know and I do understand. Our statutes, whether in the state of Georgia or in the United States, if they go into the common law and they extract a provision, some court decisions that dealt with fraud, and then state of Georgia or the United States says it is unlawful to commit a fraudulent act by doing 1, 2, and 3, then that statute now takes the place of the common law provision. So if you want to know about fraud, you have to go to the statute, not to the common law.
Well,
there's no authority in the common law anymore once a legislature exercises its authority to take the provisions of the common law, bring them into statutory law, and modify it.
Well, Paul, I dare suggest you haven't read much of the English older writer on the laws of England called Coke, Sir Edward Coke, I think is his full name. Have you read much of him?
Yes, I have read some of Coke, and once again, I have to emphasize that when this contract was entered into by the people of the 13 colonies, they charged the United States legislature, the Congress, with the authority to make all laws necessary and proper for carrying out the provisions of that contract. That means that if the legislature goes into the common law, picks up something about fraud, regardless of how it's stated, and they make it clear in the language of the statute that this applies to fraud and it can only be done this way, and this way, then it doesn't matter anymore what the common law says. The law that guides us today in our lives is the statute.
Well, I respectfully suggest that you're in error, sir.
Okay, fine.
Mr. Coke clearly declared that anything that the Parliament of England does that is outside of the clear, well-settled parameters of common law is null and void. Are you aware of Mr. Coke's words in that issue?
I am, but yes, but in the context of what he's talking about, he is correct. The Parliament had and still has a duty to adhere to the common law in whatever statute they create. However, that does not apply to the United States Congress, because the Congress can take a provision in common law and modify it for the benefit of this nation.
Well, they have to stay within the parameters of the common law.
As long as their modification does not invalidate the common law, then they are free to manage that verbiage as they see fit for the benefit of the people of this nation.
True.
So,
but at that point, the question before the court adjudicating a matter becomes, what's the common law really say, rather than what does the statute say?
No. Our Constitution makes it plain. The legislative authority is invested in the Congress of the United States, not in the Parliament of England, not in the decisions of Lord Coke.
Well, the United States law is based upon the English system of law.
Yes, absolutely.
But you seem to be arguing differently.
No. All I'm saying is that if there is a common law process that is clearly set forth in English courts, and maybe 15 or 20 English courts, they all look at this business like, for example, fraud, and they all say, this is fraud, this other thing is fraud, this over here, this is also fraud. But when the United States Congress takes all of those decisions and puts them together so they have a clear understanding of what was meant by fraud there, then they can add something to it as long as it does not change the underlying concept of fraud, or they might take something away from it that they feel like doesn't apply in this time. The point is that if a statute modifies a common law, then the statute, we today here in the United States, we are obliged to comport our conduct with the statute, not what the common law said originally.
Well,
there's a good example of that here going on in Georgia right now, and every magistrate judge in this state who issues a no-knock authorization is in violation of the common law, number one. But number two, they're also in violation of the statutory law. Now, being in violation of the common law won't get anything done to them. But here under the statute of Georgia, issuing a no-knock warrant, signing a no-knock authorization on a search warrant is a felony. And these dang idiot judges around here are doing it every dad blame day. And nobody can call their hand on it.
Right. The question is, what are we going to do about it?
Well, the legislature has been playing with a new statute to authorize a judge to issue a no-knock, and we're fighting the hell out of that. Pardon my German.
Yeah.
There is no way that even comes close. That is not a legitimate modification of the common law concept of a sheriff going to the door of a subject of the king and being required to knock first and state his business before entering upon the premises. You know, I'm one of them old timers in that regard. You're going to change the law, you better stay within the limits, as Lord Coke said in 1614, when he said something about a man's home is his castle.
Mm-hmm.
So no, I ain't gonna say
can I quickly throw some quotes at you here? In our Building Self-Governing Communities document that I'm advocating people share with their local public servants so we can get our respect for our townships and our precincts. The citations document in support of it has sections that present a quotation from California Civil Code that I can read, and also Oregon case law that reads real similarly, but the shorter one is the California Civil Code, and it says, the common law of England, so far as it is not repugnant to or inconsistent with the Constitution of the United States or the Constitution or laws of this state, is the rule of decision in all of the courts of this state of California. Right there. It says the common law is the rule of decision as far as in all the courts of the state, as far as it is applicable within our constitutional systems. Well, our constitutional system since the Revolution threw off all of the Roman Empire tyranny. And so we got a whole new level of depth and breadth and empowerment of common law here in America, in all of the states except maybe Louisiana, and California Civil Code recognizes it, and I got case law from Oregon that reads similarly, and Chris Cave from Nevada showed me a Nevada statute that reads similarly. So I dare suggest that this kind of wording is applicable in Georgia and every state in the Union, and that means that all of the courts, they can ignore statutes. They got to look to common law when they're deciding whether or not to send somebody to jail, because the common law of England, as stated right here, is the rule of decision in all of the courts of the state. It don't say the statutes are the rule of the decision. It say the common laws of England is the rule of decision there. Paul, I yield.
I don't know those constitutional or statutory provisions, but in Georgia, the common law is declared to still be in force and effect, never rescinded, never specifically rescinded, as it existed prior to, and I think the date is September 27th of 1778, I think. I do know it. I do know it is not rescinded as it existed prior to that. However, the Constitution of the state of Georgia also says that the legislature is entitled to make all laws necessary and proper for that are not in conflict with other provisions of the Constitution. So here in Georgia, we have a very clear constitutional mandate that if the legislature of the state of Georgia sees something in the common law that they need to bring over into statutory law and modify it slightly, they have every right to do that under that constitutional provision.
Mm-hmm.
And unfortunately, I think you and I have already discussed the language of our judiciary constitutional provision, so